Welcome to today's program titled Pre-Employment Background Screening and Drug Testing, Considerations for Employers in the COVID-19 Environment. At this time, all participants are in listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit your questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on CLE attendance affirmation forms. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Pamela Devada. You may begin.
Thanks so much, Donna, and welcome everyone to background screening and drug testing during the COVID-19 pandemic, what employers need to know and consider. We understand that due to the Good Friday holiday, some registrants may not be able to join the webinar in real time. Please note, as Donna indicated, a copy of the recording will be emailed to all of the registrants, and we apologize for the scheduling oversight. We are thrilled to be here with you all today during this unprecedented time to talk about a topic that is very near and dear to our hearts and our practice as it relates generally to what's going on in the world with regards to COVID-19. Please feel free to visit our resource center. We have daily updates and hundreds of attorneys working on a daily basis on monitoring different developments in the law. As you know, because we are attorneys, please understand our legal disclaimer. This presentation has been prepared by Seyfarth. It's only for informational purposes, so nothing that myself or Jen, who I'll introduce in a second, will be saying should be construed as legal advice or legal counsel, and you can read our legal disclaimer here on the slide. My name is Pam Devada, and I'm a partner in our Chicago office of Seyfarth Shaw. I lead our background screening, litigation, and compliance team. We have a team of about 50 members nationwide at the variety of our different offices. I've been practicing for almost 20 years in this space, and thrilled to provide some insight of some of the things that we've been dealing with our clients while they are really making very strategic decisions during this difficult time. And I'm thrilled to be here with one of my esteemed colleagues, Jen Mora. Jen?
Thanks, Pam. And I am senior counsel in Seyfarth Shaw's Los Angeles office. I work very closely with Pam on background check advice and counseling, and I've been heavily involved in this practice for almost 10 years. But I also advise many employers in all industries across the country on drug testing and marijuana issues, so you will be able to get a brief discussion about those issues towards the end. Thanks, Pam.
Absolutely. So without further ado, let's go ahead and dig into the substance of our program today. We've got a little over an hour to cover a topic which could be, frankly, covered in multiple hours. What we're really going to be talking about today is where are we now in the state of the world as it relates to hiring, and specifically as it relates to issues with regard to screening pre-employment and screening employees now that we are in the wake of this pandemic. We're going to talk about the different items that employers are going to be weighing and that we have seen and been counseling on really for the last month now, and that we continue to see growing and changing really on a daily basis. We're also going to focus on what hasn't changed, because while there has been really a sea change as it relates to some of the things that everyone is dealing with all of the shelter at home initiatives, most of us are not able to go into the office, for example, and some of us are essential, some of us are not in terms of what the law is saying. But there have been a lot of things that have not changed, specifically as you're relating to background screening and what applies to the law and what you have to do as an employer to keep yourself out of risk. And then we're going to talk about best practices to mitigate risk, because this is a changed time. And because of that, after you're making these important decisions, we want to make sure that you understand what you can do to sort of stay ahead of the curve. What we really anticipate is, because there is so much litigation in the realm of background screening, very, very specific litigation on hyper-technical aspects of the Fair Credit Reporting Act, of the Ban the Box laws, of the EEOC criminal history guidance, and others. For example, we think that there's likely going to be an uptick in litigation probably in the next 6 to 9 months. And so we want to make sure that companies are understanding what they can do, what they can't do, and some pitfalls here in terms of this. All right, so where are we after COVID-19? Obviously, one of the big issues that we are seeing is that many things are closing. So we've got court cases and courts that have closed, other public record repositories, laboratories, and other items of information that is either unable to be accessed or the access has been restricted in some manner. So when we're thinking about background checks, one of the main things that we're often looking at is the criminal history of individuals who we are looking to hire or looking to onboard, or, for example, have already onboarded. So the problem is when you're looking for criminal history, or you're looking for civil records or sex offender information, that may not be available to yourself or to your background screening companies based on a lot of the court closures and some of the remote working areas that we're looking at. Similarly, previous employment information. Generally speaking, when you go to get an employment verification or a reference check, you're going to have to do that, and the employer is going to need to be able to be contacted. If those companies are shut down, for example, and or if they're doing remote working and can't get access, if you mail something in, for example, you might not be able to get that information back ever, or at least certainly during the time where people are in shelter in place. And then education information. So there's a lot of information that we typically rely on in the employment screening world, and as employers, when we're making information requests, that is likely not going to be able to be accessed as readily available as it usually is. Similarly, as it relates to drug testing, applicants are often reluctant to visit labs. There may be some labs that are no longer open for a variety of reasons. We've got different types of industry as well. So on the one hand, we see some industries who are hiring at an accelerated and unprecedented pace for temporary or permanent work. On the other hand, we have many other industries who are not hiring at all and or hiring at very high level positions. So the issue that we are finding and that we're seeing is that many employers are struggling with what to do with their pre-employment screening and or post-employment screening, specifically in the area of background checks and drug tests, because oftentimes they may not be able to be completed before someone is able to start and before it's necessary for that person to start, especially in those types of industries where an employer needs to get someone in the door immediately. So what do you need to do in terms of that? That's kind of the history about where we are and level setting. So when we talk about background checks, I want to make sure that we're talking a little bit about the options that employers really have. So the companies that we have been talking to on a daily basis have been struggling with sort of three main areas of consideration. The first one really is, should I just stop background checks altogether? And the concern with that, obviously, is that certainly there are, concerns with that for lots of reasons, not the least of which is the fact that the reason why companies run background checks in the first place is to protect the safety of their employees, of their property, and their customers. So we don't see a lot of employers doing this, but there are some, and that's certainly a consideration that you want to weigh. We're going to talk a little bit more about some of the risks and benefits that potentially stem from that. Secondarily, will the type of the background checks that you run change or not? And there's a lot of considerations as we dig into this deeper, because that may impact your ability to run checks in the future. It may impact your ability to have certain legal arguments about why you're running the checks in the first place. And then lastly, should the timing of when you're running those background checks change, specifically as it relates to whether a person starts before those checks are completed or after those checks are completed. So when you're looking at this as an employer and you're thinking about the fact that perhaps you have an imminent need to hire someone, what really are the options that you've got? So option number one is that you would stop running any checks altogether. And you'll notice here we say we don't recommend. And obviously we're not giving legal advice and counsel today, but the concerns with stopping all checks whatsoever is that you undercut the argument when things go back to normal, or whatever the new normal we all will face. We have the propensity right now that we generally screen individuals for certain things. Oftentimes, like I said, it's going to be things like criminal history. Maybe you're doing drug tests. Maybe you're doing an employment verification, education verification, sex offender registry, sanction watch list, and the like. If you stop running those checks right now and continue to hire people, it's going to be very, very challenging to then, when the world comes back to some sort of state of normalcy, to argue that those checks and those potentially disqualifying items that we did not run, like criminal history, are somehow job-related and consistent with business necessity. And it's going to become a problem if you then hire these individuals and you're not screening them, and then something comes up later. It's going to be very hard to defend. So generally speaking, most companies are not choosing that option. In terms of the secondary question about what checks should you be running, one option is to maintain the status quo, right? Maintaining the status quo means you continue running the same background checks that you have always been running, and potentially drug tests. And Jen's going to talk a little bit later with her expertise in terms of the area of drug tests and what you can and can't do. And there's some very specific limitations in terms of that, depending on what state you're in. Well, same thing with background checks. So if you decide, for example, to maintain the status quo, no problem with that, except we're going to talk a little bit about the timing of the checks and what happens. The concern with running the current checks that you are likely going to be running now is the situation where some of those checks may not be completed in a very quick manner. And we're going to get to that when we talk a little bit about the timing of the checks and what you really need to consider in terms of that. Other companies are looking at what is really important to them to get somebody into the workplace quickly. So, for example, it could be that you decide to eliminate certain types of checks. Generally speaking, employment verification, employment reference checks, education, for example, take longer than other portions of a background check. So some companies are thinking about whether they want to eliminate employment or education or drug screening and really only focus, for example, on criminal history or only focus on sex offender registry checks. And again, certainly you can do that. It may shorten the time of the check, possibly, and we'll talk a little bit in more detail about that. But understand, if you are saying that these are instrumental checks that you want to have for this position, and the checks are important as to your determination of whether someone can successfully complete the job qualifications and can successfully perform the job duties of that job, and you eliminate that, it's going to be very hard to bring that back in the future when the world changes and these are readily accessible and available. So you need to be cognizant of that. And other companies are looking to see, okay, what can be ordered quickly and completely, and what can I do? So when we talk a little bit about that, what a lot of companies are really doing is they are looking at the situation of what can I get done that will be completed. So for example, you run your normal background check as a status quo, but if a court is unable to be accessed because they're closed, or your background screening company can't have the ability to verify certain information on an employment verification, for example, that you work with your background screening provider to have those checks run, but then they are closed out as unable to be performed or unable to be completed, for example. Now, obviously, if that is the case when you are doing that, you have at least the argument that you've had a good faith basis to run the same checks that you always run, that you believe are job related and consistent with business necessity, and that you believe are important. But it doesn't mean that you're never going to run them. It means that they are unable to be completed at this point in time, for example. Now, be very careful, obviously, because if you are in a regulated industry, and we're going to talk about this when we talk about the timing, even if you run those checks, if they're unable to be completed, that may or may not be good enough depending on the specific jurisdiction that you're in and the specific regulation that you are dealing with as it relates to a regulated industry. Healthcare, financial services are the ones that we see most often, especially during this time, because there's very stringent requirements on specific types of checks that you may be regulated to run. DOT is another one. Another thing that we're really looking at, and it's come full circle that I've seen this, is the question of self-disclosure and whether or not you as an employer are going to ask about an individual's criminal history from that candidate. For example, have you been convicted of a crime? Now, obviously, there are many, many state laws and local jurisdictional laws. Generally, we refer to these as ban-the-box laws that have limitations on when you can ask that question and what question you can ask. So you need to be aware of those, and those have not changed. And so please understand that those laws still absolutely apply. But we have found that a lot of companies who perhaps previously were not asking about that question have decided to put that into their hiring criteria program. So for example, asking after a conditional offer of employment, which is generally going to be allowed in every jurisdiction, after conditional offer, asking if they have been convicted of a crime with certain state law and local law caveats. For example, there's many jurisdictions where you can't ask more than a certain period of time, or you can't ask about certain minor misdemeanors and all of those. So you need to have a legally compliant question. But what that does is, for example, it allows you to see if someone has falsified, and it always has allowed you that. But in this time of this COVID-19 era, what we're looking to see is that many employers are really looking at whether or not they should add this to their hiring process, because if they can't get information from certain courts, for example, they at least have the opportunity to get that information from an individual. And if the individual is forthcoming, then they can look at that information, do an individualized assessment, and address that as they need to prior to even potentially starting an individual. And or if the person is not forthcoming and a background check shows something either at the time or after they've started a person from working, for example, then we're talking about timing next, then they can actually terminate that individual for falsification. Again, still want to follow the Fair Credit Reporting Act, but we'll talk a little bit in detail about that when we talk about adverse action as well. So a lot of things to think about what types of checks you're going to run and if you're going to change your status quo or not. The other area that we're really seeing many people struggle with and that actually may help decide the first question of what check you're going to run is going to be the timing of the checks. And so, right, the timing of the checks, option one is don't run any checks, and therefore you don't have to worry about any sort of timing. Obviously, the problems there are the safety and security. You've got negligent hiring concerns, and you've got issues that perhaps you shouldn't have run the check in the first place, because is it really job related if you're going to just stop running it on certain positions? Option 2 and option 3 are really what most employers are struggling with, though. So option 2 would be that you do the status quo, and this is really what a lot of companies are doing, meaning you don't allow a person to start work unless and until the background check is complete. That is what the most companies that we deal with, I would say it's generally accepted for many employers, though not all, and there may be a reason that you're not doing that. But a lot of the reason why companies do that is because it's a lot easier, frankly, to reject an employment offer than it is to terminate someone. When we talk about adverse action in a few minutes, you'll know there's a lot of reasons, cost reasons why there are some real risks with starting someone prior to having the background check completed. The other thing that is really important when you're thinking about that, and why most companies don't have the people start beforehand, is it oftentimes can be bad for morale of the workplace, because now you have a new person that has just started. It's time, energy, and money with onboarding the person. They have access again to your property, to your employees, potentially to your customers, and then having to, after the fact, terminate them can cause some unintended consequences. The problems, though, and this is where employers are really struggling right now, is that there is some uncertainty as to when courts or other information sources are going to be available. So, for example, if you do your regular check and you say I'm not going to let somebody be hired until this is fully completed, that could be weeks and potentially months. Many court systems right now are shut down for months. Obviously, there's a lot of shelter-in-place edicts that are across the country, and we don't know when some of those court systems are going to be available. Now, there are online repositories and other alternative sources that may be available and may be able to have your background screening company utilize to complete your checks. But there is some uncertainty. If you want a county level check in a county that is closed, for example, it's going to be hard to make sure that you get that county level check performed and completed prior to allowing that person to start, when it could be weeks or months. And you can have, you may have differentiating situations with certain applicants or others. The other thing is regulated entities, like we had chatted about, which is if you are a regulated entity that is specifically required to have certain checks run and those checks cannot be completed, what do? There are some laws that have lessened those requirements, but many, because there's been so many other laws that have been passed and other legislation dealing with safety issues, some of these have been loosened, some of them have not. And so you really need to be aware of what jurisdiction you are in to understand whether or not you're going to have the option of allowing somebody to start prior to having a full background check completed. So then the other option, option 3, is going to say, okay, well, we're going to go ahead and onboard and start the person prior to having the background check completed. And again, regulated industries, you may not be able to do that. But let's say that you don't have any law that prevents you from doing so. What are the problems with that? Well, there's uncertainty as to whether or not that worker poses a risk to you in terms of the property, your information, your employees, your customers, for example, that could lead to a negligent hiring claim. It could also be a situation where, you're not aware of something because a court is closed and there is someone who has a very violent crime that is very recent that normally would be disqualifying. Well, if you don't ask about that in the front hand, you don't know. And if the court is closed, you may not know. And then something very bad potentially could happen here. The other issue is the Fair Credit Reporting Act. And Fair Credit Reporting Act is a federal statute that was passed over 40 years ago. It's been amended a number of times. We're going to get into detail on that in a few minutes. But the issue there is it still applies. And we're going to talk about the adverse action requirements and a conundrum that really puts employers in with making a choice of whether or not to keep a person in a job or whether or not potentially to have to pay them. And Jen's going to go through in detail about the adverse action requirements that absolutely still apply. And then the last thing is, in terms of hiring someone before a check, for example, is completed, and or if it is completed as unable to perform. And I think a lot of companies are doing this, right? They're hiring someone, either they're doing the check, it's unable to perform, and then they're hiring the person, meaning starting the person, or they're doing the check and it's still ongoing and they don't know and they allow the person to start. And then the question is, well, what happens? Will you be finalizing the check later under either one of those situations? How are you going to know which checks have been completed or not? And we'll talk about some best practices as it relates to that as well. But that's something that employers are really struggling with in terms of the timing of these checks. What has not changed, and this is very important because we have a lot of companies who come to us for background screening compliance advice. And I had a client actually come to me the other day and ask whether or not the Fair Credit Reporting Act had been set aside during all of the COVID-19 issues that we're dealing with. And the answer is it absolutely has not been. You must comply with the requirements under the Fair Credit Reporting Act. And there are four main requirements under the Fair Credit Reporting Act for employers who are utilizing a third-party background screening company. We're going to go over these quickly so that we can go over some of the implications in terms of best practices and make sure that you understand the considerations. But the main piece is you must have a permissible purpose. So the four are you must have a permissible purpose. That's generally going to be employment. Whether it is pre-employment or whether it is after employment, it still is going to apply. Secondarily, you're going to have to have a disclosure and authorization if you are doing this for an employment purpose. And so what the statute specifically says is that you may not get a background check and procure a consumer report, which is the same thing as a background check, unless you've provided a clear and conspicuous disclosure made in writing that consists solely of the disclosure to that applicant or to that employee. And you must also get the authorization in writing from that employee. There have been hundreds and hundreds of class action lawsuits on this very hyper-technical area of the law. We just had a brand new opinion from the Ninth Circuit Court of Appeals come out in the last couple of weeks on this exact issue. There has been so much litigation on this since 2015, and it's not going away. So the takeaway is you are still going to have to comply with the disclosure and authorization requirements prior to running a background check, whether it doesn't matter if you have hired the person, have given them a conditional offer of employment, and or have already started the person. So understand you're going to need to do that. A lot of class action litigation under this. The most common questions that we get on the disclosure and authorization piece here is the issue of what does it mean to be consisting solely of the disclosure? And that has been truly the question in many of these lawsuits. And so, you don't want to have your disclosure form be part of your employment application. It could be part of your process, but it's better to have it as separate, standalone document. In as many ways as we can argue that it is separate, standalone, different document, different system perhaps, or a second pass of your application system, something where it cannot be alleged that it is combined with other information. The statute, of course, in the drafters of the legislation specifically confused everyone because they said you have to have this in a standalone document, but then went on to say you can have the disclosure be with the authorization. We certainly recommend as a best practice that you have those be separate and distinct forms, and that you have only the federal information that you need be in the disclosure and everything else be in a different document, whether it's state law information, whether it's the authorization, whether it's an investigative consumer report, whatever it is. You want to be very careful about making sure that you do not combine that disclosure with anything else. Otherwise, you may be ripe for litigation on this issue. That has absolutely not changed at all. Certainly, we also want to make sure, again, we talked about the employment application. Do you need a disclosure and authorization every time you run a background check? This really comes into play, especially with the considerations that we've talked about of, let's say you run a background check on an individual, part of that cannot be completed. You then decide to hire the person and start the person. And so now the person starts work, but it's 2 months down the line and now the courts have opened. Can you utilize that same disclosure and authorization that you received sort of post-offer, but pre-hiring or pre-starting of the individual? The question is, it depends. It depends on a couple of things. Number one, it depends on what is the language in your authorization. Notice I didn't say disclosure. You don't want anything ancillary or potentially extraneous in the disclosure. But in the authorization form itself, does it say that it can be evergreen? That's number one, and or throughout the person's employment with the company. If you want to rely on it, you need to have that language. Secondarily, the question is that allowed legally under different laws? And generally speaking, evergreen consents are going to be allowed. However, you need to be a little bit careful because there are certain jurisdictions, specifically California, where there is a question. It's unsettled. And the reason I say that is because the language of the statute specifically indicates that you should be getting a disclosure and authorization anytime you run a background check. And so query whether that means every time. So make sure that you understand what the obligations are and get legal counsel on when you need to get a new disclosure and authorization form if you're going to be running subsequent checks when the world returns again to some level of normalcy. What else do you need to provide with the disclosure and authorization? There are a litany of many, many other documents that you don't provide with the disclosure, but you provide as part of, for example, that secondary path of the application process or through your background screening company. Many, many different state and local laws like Los Angeles, San Francisco, New York City specifically. We have done many webinars on this in the past, and if you have a question about that, please refer to our resources page. Both Jen and myself and many other members of our FCRA compliance and litigation defense team speak on this regularly in terms of the specific laws. Most of those are found under the ban the box laws, if you will. So the big takeaway here before we get to the adverse action piece, which is the second thing that hasn't changed under the law as it relates to the Fair Credit Reporting Act, is that both the disclosure and the adverse action notice requirements are not limited to just job applicants. They absolutely apply to current employees. So just because you have decided to start someone, for example, and then run the background check, or if the background check isn't completed, the Fair Credit Reporting Act absolutely still applies. Remember I told you that there were four main issues. We've got the four main requirements under the law. Number one, you have an employment purpose or a permissible purpose. Here it's employment. Number two, you get the disclosure and a written authorization. That's what we just talked about. Number three, we're going to switch gears in a second and talk about the two-step pre-adverse and adverse action process, which Jen is going to walk you through. And number four is that you have a certification or a promise or a certification specifically to your background screening provider that you're going to do all of those things and that you're going to follow the EEO laws. If you're going to run subsequent checks, we talked about the fact you might need additional disclosures. And this is really the main other key that you want to think about is what do your offer letters say specifically as it relates to when you're going to be running a check and at conditions and or contingencies about passing a background check. If your offer letters say, for example, that you are going to be, that the job is conditioned upon successful completion of a background check, that generally is going to be fine and appropriate. If your offer letters say, though, that the start date, or you will not start until you have completed a check, you may want to change that language. Generally, it's a very easy change to say something like, this offer is conditioned upon your successful completion of a background check, which may occur prior to your start date or during your employment due to the COVID-19 court closures, or something like that, for example. You do want to make sure that you are very, very clear in your offer letters that a successful completion of a full background check, even if it is done after the person starts, is going to be a condition of their employment. Some employers are going so far as to have, if they've already given offer letters, to give revised offer letters, to give another communication that makes very clear that their employment will be conditioned upon and or is contingent upon checks that were not able to be completed. So oftentimes the background check will come back and there will be a notification that an employer will say, congratulations, your background check has been completed. Please understand there are certain portions that could not be completed, and therefore once the courts open, we are going to run these checks again, and your employment is contingent upon that. And so you need to know that, because you're going to need to still evaluate something that, if something comes up in the future, and you want to make sure that you have the ability to do so. Which leads us to the next sort of area, which is what are you going to do and what do you need to do in the case of a job-related disqualifying record. And so we're going to go to the next section of the Fair Credit Reporting Act, which is the pre-adverse and adverse action section. Before we do, I'm going to go ahead and read our CLE code. And our CLE code, for those of you who need that, is S7338. S is in Seyfarth, S is in Seyfarth, 7338. I'm going to turn it over to Jen to talk a little bit more about the adverse action process and drug test. Jen?
Thanks, Pam. So we've talked a bit about the pre-adverse and adverse process, but we wanted to take a few minutes to talk specifically about what the FCRA requires and address some of the more common questions we get about the process. The pre-adverse action notice must be provided before any action is taken, and it must include a complete copy of the report and the most recent FCRA summary of rights. We will say that you want to make sure you're using the most recent version of that summary. There have been various iterations of the summary over the years, and some of those older versions are still floating around on the internet. The most recent version is on the Consumer Financial Protection Bureau website, but if you're in doubt, just go ahead and drop me or Pam an email and we'll send you the latest. So what is considered a reasonable period of time? The Federal Trade Commission, which is the agency that used to have enforcement responsibility over the FCRA but now shares it with the CFPB, has opined in an older opinion letter that 5 business days is reasonable. But you have to be careful. You want to make sure that you consider any mailing period, because if you send by regular mail, that could actually take 2 days away from that 5-day period, leading to a possible claim that you didn't provide the person the reasonable notice. The other thing to consider is that there are some jurisdictions that require employers to wait a little bit longer than that 5-day period. So for example, San Francisco requires employers to wait 7 days. And in California, if the person advises within 5 days of getting their pre-adverse action notice that any criminal history information has been reported or is being considered as wrong, and they're getting some information to prove that inaccuracy, then they get another 5 days. So that ends up being a 10-day possible waiting period in California. So once you've waited whatever period of time is required in your jurisdiction, or the minimum 5 business days, you notify the person of the final decision with a second adverse action notice. So the Fair Credit Reporting Act requires the notice contain a statement that adverse action has been taken, the contact information for the background check provider, a statement that your provider did not make the decision and can't provide the reasons for it, and a statement that the person can get a free copy of the report, even though they already got one with their pre-adverse. They're still entitled to ask for another one if they want it, and a right to submit a dispute with their provider. Once again, there are some state and local requirements. For instance, California, if the decision is based on criminal history information, then your adverse action notice actually has to advise the person of their right to file a complaint with the California Department of Fair Employment Housing. So whenever you're working with the pre-adverse or the adverse action notice, you're definitely going to want to make sure that you include any state and local notices or text. There might be some text requirements that go in your notices. So what does this mean for employees when you find out after the fact that they have a disqualifying record? Pam's been talking a lot about onboarding people, and then later on in the employment or during employment, you find out they have something that's concerning to you. So as she mentioned, the pre-adverse and adverse action notice process still applies. Please do not leave this webinar thinking that this process only applies pre-employment when considering job applicants. That's simply not true. If you have an incumbent employee and the preliminary decision is to terminate, that is an adverse action which triggers advance notice in the form of the pre-adverse action notice that I just described. So you're not going to be able to immediately terminate that person until the process is followed, and that includes following this reasonable period of time of at least 5 business days that we talked about. So what are you supposed to do in the meantime, right? You now know that somebody who has been working with you has a potentially disqualifying conviction, or maybe some other issue has shown up. One option is you certainly can allow them to continue working. That's going to depend on your business, and you're also going to want to look at the conviction at issue, right? You're going to want to look at, does this particular conviction show that there might be a risk in continuing to allow this employee to work? Does it raise issues for your property or your information, protecting your assets, any sort of issues with employees? During this process, you're always going to have to be kind of mindful of any negligent hiring or retention claims. The other option is to put them on a leave pending the pre-adverse and adverse action process. Now, keep in mind that taking someone off the schedule and putting them on an unpaid leave could potentially be viewed as an adverse action. So our recommendation to avoid any sort of claims is to pay them during this waiting period. Now, we understand, especially during this particular crisis, that there might be employers that cannot afford to pay all their employees during this waiting period, and hopefully there aren't a lot. But what we're seeing in those situations is that employers might then be looking at the different types of convictions. And again, going back to what I talked about with negligent hiring and retention, is it kind of a more minor conviction that might be concerning, but we don't really think that allowing them to work is going to be a problem? Or is it something very, very serious where we definitely need them to stop working and having access to our information and property and employees? So this is really going to depend on a variety of issues that are unique to each employer, and ultimately it's just going to be a business decision that works best for each employer. So let's talk a little bit about some of the common questions that Pam and I get about adverse action. So did they self-disclose? Pam talked about asking applicants pre-employment but post-conditional offer, have you ever been convicted of a crime? That is still a legitimate question you can ask people in any jurisdiction, so long as it's done after a conditional offer. Keep in mind that in some states there's certain types of criminal information you can't consider, so you would need to make sure that you're advising applicants of the types of things that they don't have to provide you, but you can definitely ask the question. And if you have asked somebody that question before you onboarded them, and then later, once they started working and the background report is cleared, you find out that they actually did have a conviction that they should have disclosed in response to that question, then you can terminate for dishonesty. Now, again, not to complicate it, but keeping with the law, you still would need to follow the pre-adverse action notice process, because the law says you have to follow that process if the decision is based in whole or in part on the report. And if you wouldn't have found out about the lie but for the report, then you're arguably making your decision based at least in part on the report. So in that situation, you'll want to make sure you're still following the process. You certainly can tweak your letters to refer to the fact that they failed to disclose, but still include with the pre-adverse the copy of the report and the FCRA summary of rights. If it's a close call and it's possibly job-related, there's a couple of options, and again, this is just going to vary based on the employer's processes and procedures. You can at least start the clock and the reasonable waiting period if you want to send the notice sooner rather than later. If your process is to contact the person to get the additional information for your assessment, then you might want to make that contact before and then send the pre-adverse. Or you can send the pre-adverse, like I said, and see what information they want to give to you before you make your final decision. So again, this is really going to depend on what your process is. What do I need to send? As I mentioned, under the FCRA, you have to include a complete copy of the report and the most recent FCRA summary of rights. Some jurisdictions require additional notices or even special text, like I mentioned. The big ones are California, Los Angeles, New York City, Massachusetts, and a few others. I'll talk in a bit about some pretty onerous requirements in LA and New York City. Do I need to provide a way for the person to contact us? I mean, in reality, you're going to be, and we'll talk about this, you're going to want to do a job-related individualized assessment. And the only way in which you can do that is to have some sort of outreach with the candidate, right? Because information in the background check report usually isn't going to tell you about their rehabilitation efforts. So it is a best practice to invite applicants or employees to provide additional information they would like the employer to consider before the final decision is made. And of course, the only way to get that information is to give them some sort of way to reach you. And this is especially true in California where, for example, you actually have to advise the person in the pre-adverse. You have to invite them to provide this additional information, so there's going to need to be some contact information. How long do I need to wait? Again, at least 5 business days and possibly longer in some jurisdictions. And on the final point, yes, your background check provider absolutely can send these notices for you if this is a process that they do, if this is something that's per your contract. But just keep in mind that you will want to make sure that you vet any forms and processes, because under the Fair Credit Reporting Act, ultimately the employer is responsible for ensuring that it's done properly. So you certainly can outsource, but you'll want to make sure you partner with your vendor to ensure it's done correctly. Okay, so setting aside process, you of course still have to be mindful of any substantive considerations. So, for example, we recommend an individualized job-related assessment in all jurisdictions. And this is in fact what the EEOC recommended in its 2012 enforcement guidance on the consideration of conviction and arrest records, and is really the best practice for minimizing the risk of any sort of Title VII claim, especially if you're possibly at risk for a disparate impact claim. And we will say that an individualized multi-factor assessment is required in a handful of jurisdictions. In New York State, which has factors that are somewhat different than the EEOC's factors, it is considered per se discrimination to not do the assessment. So you'll definitely want to make sure you do that. And then some state and local ban-the-box laws have some unique requirements. So I mentioned Los Angeles and New York City. In those 2 cities, the employer actually has to document its job-related assessment on forms provided by the city. You can get those forms from us or at the city website. You document your assessment on that form, and then you have to give the applicant a copy of that assessment with the pre-adverse action notice. LA takes it a step further by even saying, if in response to that initial assessment included with the pre-adverse, the individual provides additional information, the employer then has to complete a separate reassessment section at the bottom of the form and give that to the applicant with the adverse action notice. And finally, in some of these jurisdictions, you have to identify the actual conviction or convictions that are potentially disqualifying. You have to actually list them in the pre-adverse or even the adverse action notice. The laws kind of are all over the place. It would be nice if they all got together and came up with one standard, but they don't do that. And then as mentioned, in some of these jurisdictions, you have to wait a little bit longer than the FCRA's 5 days. So turning to drug tests, we want to make sure we have time for questions, so we'll just kind of go through this rather quickly. As Pam mentioned, drug tests actually might be an issue during COVID-19, but we will say what we are hearing from those out in the field is that most labs actually still are doing drug tests. There might be a handful out there that are really focused on COVID-19 testing, but ultimately this might not really be too big of an issue, except, and we'll talk about this, employee or applicant concern about going to a lab. So you might be asking, should we actually continue to do drug tests right now? And, you know, the answer, if you're a regulated employer, is you really have no choice. And we'll talk for a moment on the next slide or the next few slides about what DOT has recently said about drug testing during COVID-19. But there are workers out there who might express reluctance to visit a lab or the testing site out of fear of being exposed to COVID-19. So, you know, we certainly encourage employers to be mindful of those concerns. So ultimately, whether to forego tests or to continue to push the issue at this time is going to be a business decision to make. Might really kind of come down to, are we looking at safety sensitive jobs as opposed to, and when I say safety sensitive, I mean non-regulated. You might want to look at safety sensitive in the non-regulated context compared to a desk job, for example. So that's going to be a business decision to take, and we'll talk shortly about some of the legal issues to consider. And there might also be some other options to explore to alleviate employee concerns, such as mobile testing companies or on-site oral fluids testing. But again, you're going to want to make sure you're in a jurisdiction where that's allowed and even available. So what about testing at a later date once the haze clears? That really isn't going to be an issue in most states, but there are a handful of jurisdictions that do regulate the types of testing that can be conducted on incumbent employees. California is one of those states that has some pretty strict case law on the circumstances under which you can test an existing employee. So if you're going to defer your drug tests to after this all ends, so to speak, I would encourage you to work with your counsel to make sure that this is going to be okay under the applicable state law. And it wouldn't be fair to talk about drug testing without highlighting the importance of staying abreast of medical and recreational marijuana laws. We could talk for a full hour about that. Clearly we won't, but we just want to remind you that litigation is on the rise and cases are definitely going in favor of applicants and employees. Setting aside what courts are saying about the issue, we definitely know of new bills proposed in a number of states, one being California, that will continue the trend of enacting employee-friendly medical marijuana laws. The other issue is to be mindful of your obligations under state disability discrimination laws. You might have an applicant or employee who says they're a medical marijuana user and they need it to treat back pain or depression or PTSD. And so what we're seeing at the court level is a lot of courts are saying that you do have to consider your obligation to engage in an interactive dialogue to discuss accommodations of that medical condition or disability that is prompting the need to use marijuana. So really across the country, when somebody says that they're using medical marijuana or they test positive or they say it's because of medical marijuana, you really want to work closely with your counsel to see what your next step is, because, you know, oftentimes when employers are losing these cases at the state court level, it's because they've kind of just said, you know, you're using marijuana, we have a no drug or a drug-free policy, you know, go away. And that's becoming problematic. So be careful there. And then we'll just end real briefly with, we did post a client alert on this, so we won't spend a lot of time on it except to say that DOT-regulated employers have to follow Part 40's drug and alcohol testing requirements. And in the bulletin, DOT said they're mindful of the issues that COVID-19 is creating, but by the way, Part 40 still applies. It gives some suggestions on things you can do. They're up on these slides. But the one thing to keep in mind, especially in the pre-employment context, is that DOT says and reminds us in this guidance that until somebody has a negative test result, they can't perform safety-sensitive jobs. So we'll see what, hopefully this doesn't turn into too many problems for DOT employers. Take a look at that client alert on our website. And with that, I will turn it back over to Pam to end with some best practices going forward.
Great. Thanks, Jen. Obviously, there are a lot of considerations that employers are really dealing with in this area, and it shouldn't be taken lightly because there are a lot of laws that still apply here. So we're going to talk a little bit about what you can do as an employer to mitigate your risk based on all of the things that we've talked about. And then we'll open it up for questions in the last 15 minutes or so. We've gotten quite a few questions, and we do want to make sure that we get to as many of those as we possibly can. So what are you able to do to try and mitigate your risk once you think about all of the discussions we've talked about and you weigh that with the issues of needing to hire people, for example, sometimes very quickly? Number one, make sure that you look at those offer letters and make sure that they are clear and unambiguous about the status of the background check, meaning when is that offer conditioned and what is it conditioned upon? And is it just the start date that's conditioned upon successful completion, or is it truly the entire employment, which, generally speaking, it's the entire employment. If you find something out during someone's employment that you didn't know about, for example, that comes up either that's changed later or that you didn't know about, you want to be able to take action on that in the wake of COVID-19 and frankly at all times. So let's make sure your offer letters are clear and conspicuous about what you are doing in terms of that. Secondarily, if you are not already asking about self-disclosure of criminal history, really consider doing that. You're going to have to comply with the ban-the-box laws. You're going to have a legally compliant question. In many jurisdictions, you're going to have to do that after conditional offer of employment. But if you do that before someone starts, you may really mitigate a lot of the potential issues that we've talked about, and specifically the ones that Jen was talking about in terms of the adverse action requirements of really making the painful decision of, do you keep someone who has a disqualifying offense in the job place, which is always very challenging to do. It also potentially affects the ability to say that it was, the conviction is job related if you keep them in the workplace, for example, with the other issue of having to pay them, especially in the type of area that we're in now, when a lot of companies are having to really look at their finances as well. Make sure you develop a process with your background check provider. If, for example, you are going to have certain areas of the background check that are unable to be completed, how are you going to be able to know that? And it needs to be very clear. You want to make sure also that your background check individuals, or the individuals in your company who are reviewing these background checks, understand what the background checks say or don't say. So, for example, just because there may be something that says review or needs review or consider or any other words that your background check provider may have on a report, it doesn't necessarily mean that there is a potential record or any record. It could mean that there's some sort of tag or alert or messaging to you as the employer that says, please note, this specific component of the background check could not be completed. Doesn't necessarily mean that indeed there is something that you need to take adverse action on. The other thing in terms of tagging reports is you want to make sure you tag those searches that were unable to be completed, so that if you do want to, in the future, specifically go back and run those searches again when courts reopen, when employers are working and can fulfill employment verifications, for example, that you can do so and you know which ones you need to do as well. Consider whether or not you're going to need to provide a new disclosure form and obtain additional authorization, specifically in California, after the fact. Do make sure that you revise your pre-adverse and adverse action letters to make sure that you are saying whatever you are doing. So, for example, if you are terminating employment, it shouldn't say that you're rejecting their offer of employment. So you need to make sure that you do take a look at those letters to make sure that they are actually indicative of the adverse employment action that you are taking. Similarly, if you're putting the person on a leave of absence, and that is what you're doing, if it's going to be paid, you don't need to tell them up front with the pre-adverse, but you definitely want to make sure that you tell them on the adverse. Make sure you provide your hiring managers and frontline folks who are talking to these people with talking points about what you have decided to do as an employer. We call it the no good deed goes unpunished, right? Where the situation is you may have a process and policy in place that you are aware of, and everybody knows where it needs to be escalated and who can say what to whom. But unfortunately, we often see very, very well-meaning hiring managers saying something to employees either when they are already hired or prior to them starting that there's a problem with their background check. That you can fall into issues with pre-adverse action and adverse action that can result in a class action if you don't have that language correctly. So make sure you provide them with talking points about if you're making a change to your process, that they are aware of it as well. And then make sure that you follow those two-step pre-adverse and adverse action process by either, if you're going to have the individual before taking action, are they going to be staying at work, for example, and or are you going to be paying the employees during the waiting time to minimize those potential adverse action claims? We know that we have covered a lot of items today, obviously not everything and all the questions that you might have. So I'm going to go ahead and turn it over to Donna, who will tell you how you can ask a question on the platform, and then we'll go ahead and get to those.
Hey, Pam, this is Jen. So I have been going through a lot of the questions, and one that has come up a ton, and maybe you can repeat the answer, is the best practice language to include in the offer letter about background checks that might not clear until after the person starts working. That seems to be a very common question.
Sure. Let me answer that, and then I'll have Donna explain how people can ask the questions on the platform as well. But as it relates to the offer letter, what you really want to make sure is that you have language that specifically contemplates the fact that a background check needs to be fully completed and successfully completed. And if it is not, then, for example, that their offer is still contingent. So what we've talked about is having language that says something like, for example, please note your offer is conditioned upon or is contingent upon successfully completing the background check either prior to your start date and or after you are starting or after your hire date, given the COVID-19 court closures or something like that. But we just really should work with your legal counsel to talk about what you're doing, how you're doing it, and making sure that is the case. Donna, do you want to talk to folks about how to use the questions tool, or should we go ahead and dig in?
No, let's just really give that information very briefly. Thank you, Pam. Ladies and gentlemen, at this time, we'll conduct the question and answer session. To ask a question via the web presentation, just type your question into the text box on your screen and then send it or hit enter, and your question will be included in our Q&A session. Go ahead, Pam. I'll let you guys get started.
Okay, thanks so much. So we've got a bunch of questions, so we're going to try and get through as many as we can here. The first one is for employment and education verifications, which may not be available. Are there options to obtain certain documents, for example, like degrees or income documents minus the income information, and are these acceptable? And the answer is absolutely. It's going to just really depend on, it's going to depend really on what you believe is going to be able to be verified. So you can ask your background screening company to gather that information for you and pass it on to you, or you can get that directly from the applicant. I will say, unfortunately, during this time, you do need to be careful because people understand that things are closed. And I don't love to admit it, but certainly there are some people that will take advantage of the situation and may manipulate that. So you do want to make sure you look for the veracity of those documents as well. The next question we have is if you opt to rerun a full background check after hiring, are there some states that you're not able to do this? And the answer really is you just need to get the consent of the person to do this. And you might have already had it at the beginning of pre-hire, but it depends really on what your consent forms say in terms of that. But generally speaking, there's not any jurisdiction that prohibits you from running a background check after an individual is hired. Now, certainly if you run a different check than you ran before, could there be detrimental reliance claims? Absolutely. The next question is, if a company hires in different locations and states and one state is closed and nothing's coming back, can you pick and choose not to run that specific state but run in other jurisdictions? And this is really what we were talking about at the very beginning, which is you need to make a determination of, are you going to go ahead and run your status quo check? And then if they're unable to be completed, then go ahead and hire the individual. Can you do that if you're regulated or not? And or are you going to pick and choose and say, I know these courts are closed? The problem is that the court closures are changing literally daily. Some of them are opening up. Some of them are opening up online repositories. Some of them have state-wide repositories that they may be contributing to, and those aren't changing because, for example, it is an automatic data feed. And so you need to be careful about that as well. All right, we've got a few more questions we're going to try and get to in the next 10 minutes here. Do we recommend creating a standalone document in which an applicant will be advised if derogatory information is found once a background check is completed, and will give an employer the option to let the employee go? And I think the answer here is certainly you need to make sure that you follow the pre-adverse and adverse action requirements if you are using a background check company. So if you're using a third party, the Fair Credit Reporting Act applies. If you're not using a third party, the Fair Credit Reporting Act does not apply. There are some funky laws, like in California, where Jen is, that requires that if you get information from another source, for example, public record information, that you have to provide that information to an individual as well. All right, let's go through a few more here if we can. One of them is, what is about state level checks? Where are they available? I think what this question is asking is what I was commenting on before, which is state repository checks. Certain states have state level checks or state repositories. Some of them are very, very comprehensive, meaning that they have all of the counties in the state, and some of them are very sporadic. And it just depends on what the state has decided to have this state level repository. So they are a nice alternative if, for example, a county may be not open, but you do have to understand that they might also not be up to date. It really depends on that state repository and whether or not that information is real time or whether that information is not real time. I'm going to send this one over to Jen. Here's the question, Jen. Our background checks are done to verify education and professional credentials and conducting a criminal search. None of them arguably are relevant to the position that not conducting a background check impedes our ability to assess a qualification for hiring. The concern is, as it pertains to stopping or bridging checks, of lack of consistency and temporary inconsistency. What do we think about that?
So if I understand the question, it's doing something different now just because of the crisis and then going back to what we normally did. I mean, it seems to me that that's okay so long as that you're clear that this is kind of a temporary thing you're doing during the pandemic. And once this all lifts, you're going back to business as usual. That would be my guess.
Yeah, I think that's right too. And I think the issue is if the argument is, unfortunately, that if your argument is that it's not job related in the first place and you don't need to run this check, really you should consider whether or not it's defensible to run the checks in the first place. But generally speaking, running background checks is going to be defensible. You're just going to need to make sure that why you're taking action and if the action that you're taking is job related and consistent with business necessity under the EEOC guidelines and under some of the ban the box laws that both Jen and I were talking about. The next question is, for example, can you elaborate further on the unable to be completed at this time for a specific service in a background check? Will you be required to complete that service once an applicant data is available or not? And I think this is really, again, a business decision and a discussion that you want to have with your background screening provider. So the issue is, if you ask your background screening provider to run the same package, for example, that you run right now on this level of employee, and there are certain components of that search that cannot be completed, do you then legally, and now that it is said unable to complete, but the background check is closed out and you hire the person. Legally, the question is, do you have to or should you run those checks in the future? That really truly is a business decision. I will tell you that most companies that we've been speaking with and most background screening companies that we've been speaking with are not keeping those as pending or open. They're closing them out so that you can hire the individual. And then after the fact, it's up to you to come back and determine whether or not, which is why you tag those, right, or have them tagged to determine whether or not you want to complete those. Most companies are, at least in the time being right now, having the discussion about whether or not they want to run those checks, and frankly, most people are doing that before as well. We've got some questions about if you need to have an additional disclosure form, an authorization form, and again, best practice is going to be in California to do that and make sure that your forms otherwise have evergreen language in the authorization in most of the other jurisdictions as well. We've got a bunch of those questions specifically as it relates to that. One other question we had is if it's just updated, is it a new report or not? And I think it really depends on your conversations with your background check company of whether or not this is an update to the report or whether it is a true new consumer report. And I think that's really going to depend on when the report was closed and what the report says as well. All right, we talked about the offer letter language already. I'm just scrolling through to try and see if there's other ones that we have not covered in the past here. We talked a lot about the offer letter. Is there any reason or any time limit on rendering a decision after the person provides information? So I'm assuming that this is either related to a question of the pre-employment question, right? So the post-conditional offer, but self-disclosure question, or during adverse action. And so many of the different local and state jurisdictions have very specific parameters, as Jen was talking about, in terms of if someone provides you information after you send them a pre-adverse action letter that you have to evaluate in a certain manner. New York City has the Fair Chance Act, so does LA. Certain other jurisdictions have things that you have to look and rely on. If the question is going towards, is there a time limit in terms of when you might make that decision, I think the answer really needs to be is you don't want to take action on stale data and you don't want to wait too long to take action. So for example, if you run a background check today and then you decide to make an employment decision 2 months from now, right, the information in the background check may or may not be still accurate. right? A record could have been expunged, for example. And generally speaking, the general recommendation is that you should not keep a background check or make a decision on a background check more than 30 days out. That's at least the guidance that we have from the FTC, and certainly some of the information in the Fair Credit Reporting Act. So we have time for about one more question. So I'm going to look here and see if we can find one here that we haven't answered. I think we answered the question about jurisdictions that state drug tests or background checks after hire. Certainly as it relates to background checks, the answer is no. Jen, you want to just talk about some of the jurisdictions that might restrict a drug test after hiring?
Yeah, so those would be California, although there's some exceptions for safety-sensitive jobs, which could be healthcare, people operating forklifts, people on the road. And then the others that I'm aware of off the top would be Connecticut, Iowa, Minnesota, Oklahoma, Rhode Island, and Vermont. Those are pretty much your heavily regulated drug testing jurisdictions. So I'd be careful in those states doing a test after employment because the statute might say you can't.
And then the last sort of question that we'll get to really is the question of regulated industries. And these are really the hardest, right? Because certain regulated industries require fingerprints to be done, require certain level checks to be completed, require that you can't hire someone who has certain, for example, certain disqualifying convictions per statute. And the thing there is you need to make sure you understand what the statute specifically requires, and that you do everything you can to try and comply with that. So, for example, if a statute requires that you must fingerprint someone and you run the fingerprint checks and they haven't come back, well, it depends on whether or not the specific statute requires you to have the fingerprints, or under like a Section 19 issue, with financial industries, does it require that you just not hire someone who has these certain convictions and or potentially arrests? And so then the question is going to be, then what I really think you need to do is take a look at what are all of the alternative things you can do. You can ask the person. You can run, different types of proprietary background checks through your background screening company. Perhaps you do a statewide search or another alternative search. All the things that you need to look at to stay, if you're ever challenged, right? Look, we did a reasonable period to try and comply with the statute in any way that we possibly could, given the limitation of information that we had available to us, given the COVID-19 crisis. So with that, we are out of time. We really appreciate everyone being here. I'm going to pass it over to Donna, and thank you very, very much.
Thank you as well.
Thank you all. This concludes today's webinar, and we thank you all for attending.